Pre-drafting preparations. Drafting a protected areas law requires careful preparation. A legal drafter must consider relevant constitutional provisions, international treaty obligations, existing policies, existing laws, and institutional frameworks. Each of these factors will influence the form, nature, and content of the protected areas law. A drafter must also consider what procedures should be followed in drafting a protected areas law. These should include a consultation process involving stakeholders, experts, government, and the public, and a formal approval process for enacting the final law. Finally, a legal drafter must consider the form of the protected areas law. A protected areas law can be general or site-specific, standalone or part of a larger environmental framework, primary or subordinate, such as a regulation. In some cases, a drafter may be amending an existing law rather than establishing a new one. This will involve similar pre-drafting preparations. Preliminary provisions. Most protected areas laws contain preliminary provisions on definitions, scope and application, objectives and principles, and institutions. Knowledge of these provisions is key to understanding, implementing, reviewing, or drafting protected areas laws. Definitions should provide clarity and not uncertainty. Definitions should not contain substantive rules. Definitions should draw on international treaties and guidelines. Preliminary provisions set out the scope and application of a protected areas law. These should lay out the geographical scope, whether the law applies to the entire country, to a particular region or province, or to a specific protected area. The substantive scope, whether the law applies only to certain governance types or certain management categories, and whether it applies to marine or terrestrial areas or both. And the relation to other laws, such as framework environmental laws, other natural resource laws, land use planning laws, and pollution control and waste management laws. Preliminary provisions should identify the objectives and principles of the protected areas law. Objectives could include a primary objective of long-term conservation of nature and secondary objectives relating to nature conservation, ecosystem services, and social and governance goals. Principles should draw on internationally agreed approaches. The protected areas law should set out mechanisms for implementing the objectives and principles, and indicate whether they are binding or non-binding. Preliminary provisions should set out institutional arrangements for implementing the protected areas law. These include policy institutions, administrative institutions, advisory authorities, management authorities, and co-management authorities. The protected areas law should identify or establish relevant institutions and authorities, prescribe institutional powers and functions, and create mechanisms for cooperation, coordination, and consultation between institutions and authorities. Main messages. Drafting a protected areas law requires careful preparation. Definitions play a key role in interpreting a protected areas law. It is vital to clearly delimit the substantive and geographical scope of a protected areas law. Protected areas laws should prescribe a set of principles and/or objectives guiding their implementation. A protected areas law must create the institutions tasked with implementing it and set out their functions and powers.